everyone hear me okay? Great. First, I'd like to congratulate the VJEL team on putting together such distinguished panels today. It's a very exciting lineup, and it's my privilege to introduce you to the panelists here, who will be talking about legal barriers to renewable energy generation today. And so my job this morning is to give a brief introduction, and for those of you familiar with these speakers, you'll realize what a difficult job I've been given their very accomplished careers today. First, we're going to have Stephen Pike. He is the Chief Executive Officer of the Massachusetts Clean Energy Center, and he'll be speaking today about state incentive programs to encourage clean energy development and integration. Mr. Pike leads the Clean Energy Center's efforts to build a nation-leading clean energy economy in Massachusetts. And prior to joining the Clean Energy Center, first as General Counsel and now, as I said, as Chief Executive Officer, he practiced corporate law in Boston for over 15 years. Mr. Pike is a graduate of Yale University, where he got his bachelor's in history and gained his JD from Boston University School of Law. After Mr. Pike, we will have Carl Rabago, Executive Director of the Pace Energy Climate Center at the Pace University Law School, where he engages in regulatory and policy proceedings focused on clean energy solutions. Mr. Rabago has over 27 years of experience in energy and climate policy development and regulatory markets. He's been a utility regulator, utility executive, renewable energy developer, law professor, and clean energy advocate, among other things, giving him a unique insight from multiple perspectives. Mr. Rabago is also on the board of the Interstate Renewable Energy Council and the co-director of Northeast Solar Energy Market Coalition. And he'll be speaking today about solar net metering, value of solar tariffs, And finally, we will have our own Vermont Law School graduate, Graham Jesmer, who is an assistant counsel for the New York State Department of Public Service, and he specializes there in transmission and generation siting, as well as telecommunications regulation. Mr. Jesmer has the distinguished experience of being an energizer at the Institute for Energy and the Environment, so I'd like to welcome him back today. And he'll be speaking about renewable energy siting from a law and policy perspective in New York. Each of our panelists is going to speak for 15 minutes, and once all three have spoken, we'll open it up to questions from the audience. Just as before, you can line up at either microphone and ask a question. So, welcome, Mr. Pike.
Great, thank you, and good morning, and thanks to Russell and Liz in particular for having me here this morning. I am indeed a reformed lawyer at this point. An answer or a potential answer to the student's question, how do I branch out? I would encourage you to connect and stay connected as best you can to anybody and everybody in your professional and personal world, because that's how I ended up where I am today. It was a relationship that I built in 1991 that led me to the Massachusetts Clean Energy Center. So just a real quick poll. Anybody ever heard of Mass CEC? Anybody know about that? Oh, wow, okay, terrific, wonderful. So you already know that we actually are the answer to all of the questions that have been asked this morning.
All right.
Yeah, that may be a little aggressive, but just a quick word on Mass CEC. We're a quasi-public organization, so certainly not private sector, certainly not nonprofit, not quite government either. We're a little bit in that netherworld, but it does provide us flexibility to provide some solutions that a typical government agency really struggles with. And what we try to do and are trying to do and will continue to try to do is to develop a clean energy industry in Massachusetts that essentially can stand on its own. We're fundamentally an economic development agency. Pardon me. So we come at things with that type of perspective. One thing we are not a regulator. We are also not a policy shop. At the same time, to take Dan's triangle, we like to actually think that we are right in the middle of that triangle. Because we do work on technology development. We have a whole series of programs that help entrepreneurs and academics pull their technologies from the lab bench all the way up to early commercialization. We do company development, which would be in the finance side of things. We make venture capital-like investments in companies, equity investments, debt investments, and the like. We are also involved in deployment. Helping commercial businesses as well as residents, universities, and the like to actually install clean energy technologies on their facilities. We're also involved in workforce development. So we're very focused on helping to create the next generation of clean energy workers. And we also actually own clean energy assets. And so this is a little bit different. We don't own solar panels, we don't own wind turbines and the like, but what we do own is we own and operate a facility in Charlestown, Massachusetts, that is the largest indoor test blade facility in North America. It's called the Wind Technology Testing Center, and currently they are testing blades 50 to 60 meters in length. These are typically not quite the first prototype out of the mold, but the second, quite frankly. Working with blade manufacturers from all over the world, although unfortunately that industry is consolidating rapidly. And we're equipped to test blades upwards of 90 meters in length. So we still have a ways to go before we get there. I will say about that facility, frankly, my primary point of pride with that facility, that as a government-run agency, we have actually, on an operating basis, been revenue positive, if you can believe that, for 4 straight fiscal years, far earlier than we were expected and predicted. And frankly, if we had even achieved that in a single fiscal year at any point in time, I would have been proud. But to have done it 4 years running is really quite a tribute to the team over there. The other asset that we own is actually a marine commerce terminal. So we built a purpose engineered and constructed facility to help deploy offshore wind projects off the coast of Massachusetts, and I'll get back to that in a few moments. So given our agency's perspective, I don't know whether I'm going to simplify this or complicate it, but I'd like to look at just barriers. So not just legal barriers, but also think about financial barriers, think about policy barriers, think about technology barriers. And in each of those areas, what our organization does is we typically take a pretty close, and sometimes some would say a rather extended, look at what those challenges, what those barriers are. And to pick up on a theme that Dan touched on very early in his remarks, we look at those as opportunities, opportunities for our engagement, because they are typically areas where folks are very hesitant to go. And so we look at those as opportunities, and in particular, opportunities for innovation. So we often talk about not just technology innovation, but also business model innovation, policy innovation, finance mechanism innovation, and the like. And what I'm going to try to do is touch on a few of the programs that we've been working on, or areas of focus that we've had, and give you some idea of sort of how our thinking has evolved over the years. Now, one thing I will say is we haven't been around for all that long. We were actually created in 2009-10, which in and of itself is quite a story. It was about a 3-year journey. And so, our history, while not long, I think is considerably deep. And we are typically involved in, in all of the cutting edge work that's going on in Massachusetts, which All right, so I need to do a little bit of a plug. Dan talked about efficiency. I'll let you know that Massachusetts has been ranked #1 in efficiency 7 years running, outranking California and other relatively progressive states like New York, Vermont, quite frankly. And interestingly enough, and this will get to sort of the innovation side of things, the Bloomberg Innovation Index last year also ranked Massachusetts as #1. So I think, those two data points give you a pretty good idea of some of our sort of attributes and assets. So I'm going to start with solar. Massachusetts has had, particularly for a state as far north as it is, tremendous success. Depending on what sort of metric you use, generally we're in the top 5, certainly in the top 10 as far as solar is concerned in the US. And that can strike a lot of people as a bit curious. How is it that Massachusetts 5 years ago had 7,000 systems installed and now has over 75,000? So at MassCC, which is just one part of the solution, and actually Carl is going to touch on another part of the solution, at least in Massachusetts. So we've had the legislature that's been involved in net metering, and quite frankly, as you might expect with any legislatively driven process, that is pretty much a mess from time to time. We have also had an SREC program, so certificates. You produce a certain amount of power and you get credit for it, and you can sell those on the market. And the third piece of it has been our role, which again has evolved over time. What we have really tried to focus on is, of course, the affordability and accessibility. So certainly those market barriers that existed and continue to exist for many people in Massachusetts. So we started out with a rebate program, pretty standard government fare, nothing particularly creative or inventive there, but it really started to weigh on our balance sheet. And so we are funded, through a systems benefit charge on utility ratepayer bills. Well, that provides only so much funding. We don't go through typical government appropriations processes. We rely on this funding as well as some other government funding that from time to time we get from other agencies. So this program, probably about 3-4 years ago, 1/2 of the fiscal year, it consumed 1/3 of our revenue stream. So you don't need to be, a financial genius to figure out that as that grows, that is simply unsustainable. So we turned off the spigot on that particular program. What we realized was a couple of different things. One was not only could we not do this, but banks weren't doing it. And why is that? Why is it that banks were so hesitant to finance an asset that actually produces revenue? Right? They have no issue going in and financing, a home improvement that doesn't provide revenue, a new bathroom, a new kitchen, those granite countertops or what have you. So what is it about solar? And frankly, it's a lack of familiarity. So we thought, well, okay, so that, what we need to do is to figure out some ways to make them feel a little more comfortable with this. And so what we did was we set up a loan program. And so we don't provide the loans to homeowners. What we do is we provide funding to the banks. And we buy down the interest rate, and then we also have some pieces and parts that are particularly focused at low and moderate income homeowners in Massachusetts. So the idea was to provide a financial package that would make it worthwhile for those banks to step into the market and take a little bit of a risk. Not that we see it as a risk, certainly not a technology risk, but the banks do. And so we've been working on that, we've been working on that for a couple of years now. And we've added over 3,100 systems to Massachusetts. It's leveraged over $100 million private dollars. And we, at this point, are now shifting that program to focus, thank you, focus solely on low and moderate income homeowners, which to date have actually taken advantage of 65% of the funding that we have provided. So a program that I think, has identified some barriers and, and brought in a whole new set of players in Massachusetts that will be required in order to sustain the program long term. So the second area is storage. Again, Dan touched on it a little bit earlier, but it certainly is seen as sort of the Swiss Army knife, right? That's going to make so many things much easier and work a lot better on our grid, as well as with renewables and the like. And so this is an issue that actually has become very near and dear to our governor's heart. Believe it or not, I was at an event maybe 3 or 4 weeks ago, and he actually went off script, went off an impromptu monologue on the value of solar, and quite frankly, he was pretty much spot on, which was pretty impressive given all that he has on his plate. But what we needed to do was somehow move the needle. Massachusetts, even now, I think we have somewhere in the order of maybe 7 installed megawatts of storage in the entire state. When we started this effort, we had 2, which is a paltry figure. So one thing that government agencies can do, even if we can't necessarily provide all the financing, what we can do, and again, it's very consistent with Dan's comments, is we can provide the focus for the effort and the initiative, and then perhaps a little seed funding, to get things going. Again, to get markets, to get developers, to get the utilities a little more comfortable with these technologies. And so we undertook a study with the Department of Energy Resources in Massachusetts. It hit the press with what in energy circles, at least in Massachusetts, which was quite a bit of fanfare. And the governor has committed $10 million to help seed some projects. We're actually in the process of evaluating those projects. We should be announcing those by the end of this month. In conjunction with that, the Department of Energy Resources had established a target for Massachusetts to hit by 2020, which from a project development standpoint, if you've ever done it, is right around the corner. And so, trying to provide some of those different mechanisms to push the industry forward. We've also been working with manufacturers in Massachusetts, trying to figure out how we might be able to combine solar with storage in order to help them, particularly, peak shave. Again, this is entirely, weaves in very well with Dan's comments, trying to make the economic argument. And that is, that's one that has been very successful. So we're looking forward to pushing those projects forward in the storage area and seeing how, to what extent. I'm very encouraged by it because I think what it's going to do is unlock a lot of these challenges that we've seen in business models and in policy initiatives in the state. To really help to start to solve some of those challenges. So I'm hot on the clock here. I just want to touch one other area very quickly, and that is offshore wind. So I will take issue with one thing Dan said. He mentioned California and the Great Lakes as being the hot spots for water-based wind, offshore wind. As far as Massachusetts is concerned, we have considered ourselves to be basically the Saudi Arabia of wind. And that is because we have wind speeds in these areas south of Martha's Vineyard that we've actually been doing some monitoring, and they, on average, are up over 20 miles an hour day in and day out. But again, we can, and this is to Dan's point, we can't afford to help finance those projects, right? Those are multi-billion-dollar projects. That's not something that we can get into with our relatively small balance sheet, and it's not something that the state has an appetite for. But what we did do is we did a lot of pre-development, a lot of pre-construction work, trying to set the table So we did wildlife studies, the birds and whales and turtles and the like. We worked with the fishing industry, which is a significant industry in Massachusetts and up and down the Northeast coast, to shrink the sites that we're looking at for offshore wind. Those shrunk by 60% based on that input. Over 100 stakeholder meetings, local municipal officials, federal officials, state officials, wildlife, environmental advocates, and the like. So a lot of that's what I would consider to be sort of low-hanging fruit, capital light type of work, but it really has laid a good baseline of information for the developers that are now looking to build these projects. The other piece of that, of course, is they needed a path to market. There was no way to get to market, and so this is where the legislature and the governor and other policymakers, we hope, really got it right, and they moved remarkably quickly. It was truly a real compliment to the work that the legislature did. Basically, a year from kicking off the effort, they had concluded the effort. And Massachusetts is the first state in the nation to have a relatively clear path to the market. It's underway now. The utilities are mandated to go out and take bids from offshore wind developers. They are not mandated to actually enter into contracts, but we're pretty optimistic that they will. That the bids are due right around the holidays, just before Christmas. Decisions will be made by the end of April. So, again, some initial market development barriers, and clearly, construction and financing barriers that Massachusetts has looked to overcome. From this point forward, we'll be focused on supply chain and workforce, because that's where the real, where the real economic development opportunity is from our agency's perspective. And that's an area that we'll be focused on in the months and years to come. So thank you. I appreciate you indulging me with a few extra minutes, and I certainly look forward to the discussion.
All right. I'm not giving up any of my time. That's not how it goes. But I hope I don't exceed my time by any more than you. That's my goal. Okay, good. And where do I point this thing at? Over you? Okay, good. All right, so thank you very much for being here. A beautiful place, beautiful time of year. Get a chance to see heroes and colleagues, Peter and Michael and Kevin and Pat and Dan and others. There must be something attractive about this place that you get these great people here. So thank you for letting me be one of them. I want to talk about the value of solar as a kind of a deep dive case study on some of the issues that are coming up with what a lot of us have described as a revolution in scale in the electric utility industry, something we've started work on actually decades ago at Rocky Mountain Institute. We tried to compile into a study called Small is Profitable, and that I got a chance to work on when I was at Austin Energy. I need to start because a couple of people said net metering, and I just want to make absolutely sure the baseline is uniform. Is anybody, I'll just remind you, just in case some of you don't know what net metering is. Once upon a time, all electric meters were metal discs that spun in a particular direction, backwards for some reason, the needles too, in order to record consumption of electricity. So as the juice flowed by, it impelled this disc to go around, and like a clock, it moved some arrows, and a meter reader would come by, read the forward progress of the meter each month, and charge you accordingly. Some customers started doing things where they generated themselves, and they wanted the meter to spin the opposite direction when they made electricity. The first thing that had to happen is the meter people from the utility had to come out and remove a little detent screw that actually prevented the disc from going in the other direction. And then the force of energy from generation would counteract the force of energy from consumption. And once a month, the meter reader would come by and he would measure the net forward progress of the meter. That's net metering. It's a netting of your consumption and your production, and you only pay the difference, the net. So it is, in legal parlance, rough justice. It is an idea that you get an equal and offsetting credit for your production, equal and offsetting to your consumption charges, because utilities were constructed as cost of service entities. That means that the rate they charge was supposed to be the stack of costs associated with providing you that kilowatt hour of electricity. And we said, well then, if that's what it costs to get it there, then if you make it yourself, that's the credit you ought to get. That was net metering, and it was just fine when nobody did it and solar was too expensive to deploy. And then it got affordable and customers chose to do it even when it wasn't affordable, and utilities said, oh my God, there go my revenues. Longer story associated with that, but that's the baseline. The value of solar concept is an idea that I came up with. The piece I came up with was using the term value of solar for a new kind of tariff to substitute for net metering, because when I was running the distributed solar program at Austin, I had these apparently conflicting objectives. One was that I was told by the city council that I was supposed to make a lot of solar happen. And second, I was giving out rebates and watching revenues get eroded by customers self-generating. And I had to figure out how to make both of those work. The value of solar rate was an effort to come up with a way to serve the interests of those solar customers, serve the interests of my bosses, the community, and serve the interests of the utility as an enterprise function operating in the city of Austin. So that's your baseline. What I want to do is take you through some of the fun kind of legal barriers issues that it raises. Quick commercial about PACE. You can read this. Somebody asked, what should you do if you get grounded, well grounded here at Vermont Law School in policy, but you want to learn how to move into finance and the practical and technological issues? I suggest you do what I do, which is go to PACE and get an LLM. I was teaching at West Point, my last tour in the Army, and I got assigned the environmental law class to teach to the cadets. And just luckily, just down the road was PACE. A guy named Dick Ottinger had just started this thing called an energy center, the energy program there, and I got involved. And the reason I tell you this is because it turns out that focusing on something practical can really work. I didn't know anything about environmental groups except for they were goofy, they had long hair, they didn't shave, and they were really sincere. So I actually got permission from one of my advisors to spend 3 credit hours doing practical research. I heard there was this environmental group across the river called the Hudson River Keeper, and I volunteered to do some work with them. I went to Bobby Kennedy, who was their lawyer, and I said, I need a project. He said, count fish. So I had to do a lot of legal archaeology to find out how many fish are killed on the cooling water intake side of power plants in the Atlantic seaboard. The reason I tell you this is mostly for the law students' benefits. I dug in and understood the technology, I understood the regulation, I understood the law, I got to write an article about it, I got to write the lawsuit, the last great non-discretionary duty lawsuit in the Clean Water Act. 17 years later, I got to see it go to the Supreme Court, and it launched my career. So seek the practical, and you can do it at PACE, where we get involved in all kinds of things, from rate cases to technology and all that list of things there. Oh darn it, okay, that's a translation problem. What you can't read there is, let me make sure the words are right, sorry. Tax base and credits and then emissions is underneath it. So for law students, this is issue spotting. And what I want to start with is understanding what is a kilowatt hour and what is it worth. And that's the core of the value of solar concept. It's a deconstruction of this delivered unit of electrical service that we measure and denominate as a kilowatt hour. That's energy. And what we ask ourselves was, what's actually in it? And what's actually in it is a bunch of stuff. We think of it as energy, but it actually composes a lot of costs, benefits, or / avoided costs. We borrowed a page from PURPA, the Public Utility Regulatory Policy Act, and its concept of avoided cost as a way of measuring benefits and ultimately indicating the compensation that you should receive. And we took the bundle of sticks apart. That's the first sort of core thing about what we're doing. Now, as we took it apart, we quantified and we monetized, which means you had to get economists and people who knew how to use Excel spreadsheets, not me. But they were good at it and started helping us. We also used consultants. That's another good thing to say. We wanted to rebundle this into a tariff, which I simply described as a public contract that is binding merely by acceptance from a qualified buyer. It may not be the perfect definition, but it works for me. The idea was we needed to write up solar into something that every solar customer just could get and could use, but that address those issues that we talked about before. Tariffs have to be fair, they have to be efficient, they have to advance multiple sort of goals, not just the goal of getting the tariff written, but also integrate well with other company goals. And the list I put up here also concludes with, it's got to be something people can understand. I did a novel thing in the utility industry when I came up with the value of solar tariff. I went to my solar customers, and I started with a proposition that said, if I compensate you fairly for your production, can I charge you fairly for the services I provide you? And I got to tell you how novel that is. The utility conversation normally starts with, I want to charge you something, but maybe I'll give you something back. And it worked really well in the other direction. So we're going to unbundle the bundle of sticks. We're going to figure out what everything's worth. And then we're going to figure out a way to plug that into a tariff. We were not writing on a blank slate. So this is do your legal research. I already mentioned PURPA. We had done work, that work I did on cooling water intakes and that Dick Ottinger started at PACE back 27 years ago was a comprehensive study of externalities. We're thinking about the unmonetized and unquantified costs or benefits associated with the service. That's what economists call an externality. We've had some experience with green power, letting customers pay a premium price for selectively procuring on their behalf some green energy. This was back in 2010 or 11. As I mentioned, we had written Small is Profitable, where we chronicled all 207 warning. If you spend time with the mind of Amory Lovins, the numbers just get exponential. But we wrote the comprehensive list of all the benefits of making your electric resources right size. And we had been gaining some experience with planning done at the local level so we could understand the impact of distributed resources at the bottom end or the edge, the distribution edge of the system. So it wasn't the first thing we did. We also focused heavily on what we had. And what we had in net metering is a bunch of very real, sincere problems. And you can read all about it, but basically, utilities didn't just dislike net metering because they lost revenue. They felt it was inaccurate. They also suffer real problems between rate cases if customers use less than they forecast. It creates a revenue shortfall, and revenue shortfalls create the need for rate increases, and rate increases are politically unpopular. So net metering was seen as a contributor to this problem. We needed to know what solar was worth if we were going to address that question straight up. From a legal point of view, we took those stack of values, and this is a chart of where they come from, but I want to point out for the lawyers that even though we can start at the simple utility stuff like energy and capacity and the more complex stuff like grid support services, we start looking out at things like financial risk, social issues, security risk. These are things over which regulators and utility lawyers have relatively little experience, and some would argue do not belong in the jurisdiction of the utility business model. So there's some interesting legal issues. We're having them writ very large with the recent DOE proposed NOPR. They're raising the issue of whether resilience should be a component of a wholesale rate for electricity. So jurisdiction is the core of understanding how to implement this stuff. If you have a very narrow view, you won't capture all the values. If you take a broad view, you have a better chance at it, but then you might be meddling in other people's sort of policy tariff, and you have to have a more coordinated approach. There's also a transactional view of the jurisdiction. Who's in charge of the relationships and the flows between external and internal entities in the utility mix? Customer and utility, regulator, those are pretty easy, but what happens when you have third-party solar providers that aren't regulated as utilities? So again, for the lawyers, this raises a whole bunch of issues. You put it all together and you can come up with a stack. So you take the sticks and you put them back together after quantifying and monetizing them, and you can estimate what a kilowatt hour of electricity generated by a customer at their distributed energy facility, their rooftop solar, is worth. And that's the ultimate objective of value of solar, because now you can imagine that's the credit they can earn under the tariff that you design that accomplishes all those goals that you've set forth. Here in Maine, a relatively recent one of these studies, they've been happening a lot of places, we found that solar was worth about 33 cents, even though the retail rate is only about 13. So solar customers are net subsidizers of other customers on the system. But there at the bottom are those pesky societal benefits that some people don't think belong in an electricity rate. More debate to happen. What's fun about the value of solar is you can use it not just for valuing solar, but all distributed energy resources. And I quickly list them off as the other 4 S's. So, or the other 4 of the 5 S's: storage, smarts, savings, as in energy efficiency, and grid security. And you can start imagining that as we are doing in New York with a value of DER approach, that it's at the core of the reforming of the energy vision process, which is intended to transform the old cost of service model into something new. So this little value of solar idea has a chance to grow. There's also a bunch of other legal barriers that are related to policy. I won't get into them, but they have to do with the climate that the state and its regulators and legislators have created for distributed energy resources. Like just, simple examples of whether or not you can put solar in the best and most optimal locations to maximize its value once you have the formula, or whether or not you're held back by parochial concerns. My proposal for Vermont is if we could paint solar panels to be black and white, looking like cows, you guys would let them be anywhere. But some people don't agree. I don't know why. Let me just close by sort of picking up a point that Pat made at the very start. It's sort of, how long does it take? It is going to take a while. This is probably the most capital-intense industry, the electricity industry, that exists on the face of the earth. So changing that much capital is difficult, but do not sell new ideas short. I used the term value solar and applied it to that tariff for the first time in 2011 when I got it approved by the city council. I checked the other day, and value of solar now has 23 million hits on the internet. Everybody is talking about it as a way to move forward, because it was, this lawyer's idea that maybe we could introduce an alternative approach to a common set of problems and conditions. I invite all of you, but especially the students whose brains are much less encumbered by experience, to understand that it's gonna take a while, but there's some really important things you can do now and start doing now to help us get out of the mess that we've created for you. So I'll stop there. Thank you.
Good morning, everybody. Thanks to Russell and Liz and the whole VJEL team for having me. I was in their same position, about 5-6 years ago now, so it's nice to be back here in Vermont and to give some insight to, especially to the law students, about how siting works in New York and how some of those lessons can translate across state barriers and even to the local level. So just a very brief amount of background on myself. I've been working around energy for just about a decade now. first as a reporter with what's now Renewable Energy World, and then spending 3 years here, 2.5 of which working for Professor Dworkin and Jones at the Energy Institute, and then right after graduation, starting at the New York State Department of Public Service. In that role, I am, make sure that works, yep, assigned to our siting and telecommunications group. Most of my work these days is on the siting side. And what I want to do is cover a few topics. First, set a little bit of context for how siting works in New York. Then discuss some types of analysis that we require in New York and that I think would be valuable even in states that may not require it at this point. A lot of it's going to be familiar to anybody here with some environmental background, but there are particular quirks in the process when it comes to doing these studies for renewables. Then some practical approach lessons, things that, you know, from the regulator's perspective that we have seen that are good best practices for anybody who might be working for a solar or wind developer in the future. And then I'll just bring it back together for some takeaways. So a little bit of New York background. New York has a energy siting statute today called Article 10. We refer to the old statute as Article X in order to differentiate. That was enacted in 1992 and had an 80 megawatt trigger to bring it under the state's jurisdiction. The problem with that trigger was that it was based on nominal output and not on nameplate capacity. So developers played games with installing a 94 megawatt nameplate unit and saying they would only run it at 80 megawatts and getting handshake agreements to do that. So it created a lot of problems. The only projects certified were all fossil fuel. There were no renewable energy projects certified under Article X. And it eventually expired in 2002, which set us at a point where it was all local review. So in New York, that's the State Environmental Quality Review Act, SEQR. It's basically anytime a town were to approve a project, they needed to go through an environmental review. It's similar to the federal process and EIS and the like, but obviously having the towns do it for relatively large facilities was problematic. They don't have the expertise, they don't have the resources to be able to do a proper review. So in 2011, the legislature enacted and Governor Cuomo signed into law the new Article 10. It tried to correct some of the problems with Article X, namely that it now has a 25 megawatt nameplate threshold set at whatever the generator is deemed to be, that being the turbine in a fossil fuel facility, adding up all the inverters in a solar facility, adding up the nameplate on wind turbines for a wind facility. So far, we've only had renewable energy projects come in under the new Article 10. Mostly wind projects, those were the first ones in the door. More recently, some solar projects, but most of our experience thus far under Article 10 has been wind-related. Renewables were certainly contemplated in the legislation, but maybe not to the extent that fossil fuel was, so it's been an interesting process to try to adapt what are fairly straightforward studies for a central station fossil fuel facility for especially wind and to a lesser extent solar, and I'll touch on that in just a minute. We've also, for the legal side, an interesting exercise for us has been to try to figure out what makes one project versus multiple projects in the renewable context. Do five megawatt solar projects that all tie into the same gen line but are operated by separate but related LLCs count as one project or multiple projects? We don't have a firm ruling out on that, but it's just an interesting question to think about, in terms of what makes a renewable energy project. So some quick process highlights, and this is fairly straightforward administrative law stuff, but I'll just run through it. So under the new Article 10, it's a pretty robust process. We've got a host of pre-application procedures, including a public involvement plan, which is really designed as an early stage engagement with the state regulator as well as local entities, everyone from the towns to school districts to fire districts, building inspectors, you name it, and we kind of encourage developers to engage with those parties. That comes in, we have some comments back and forth. Next on the list is a preliminary scoping statement. This is sort of the applicant, the developer's first opportunity to tell us These are the types of studies we intend to give you in our application, presenting everything from environmental impacts to economic impacts. And again, I'll get into some of the specifics on those in a few minutes. We then have an optional, though strongly encouraged, process of stipulations, where the developer sits down directly with all the involved state agencies and ultimately all the towns and any other interested groups who make themselves parties to discuss what the final scope of those studies is going to be. And it's a negotiated process, and we reach a signed set of stipulations that eventually goes to the siting board, which is ultimately responsible for making the decision, and it'll form the basis for the application. So we know, at least from a content standpoint, what will be coming to us, even if we don't know necessarily what the results would be. Then it's the application, it gets filed, it gets declared complete or not. There's some timeframes involved in that I don't really want to spend the time to go into. Then the application is filed, and it's your standard administrative type process. Completeness determination, discovery, pre-filed written testimony, hearings, and or a settlement if that's the route the parties choose to go, written briefs on exceptions if there's a decision from our administrative law judge, and then ultimately a siting board decision. Like I said, it's a pretty straightforward administrative law process. So this is going to be a little hard to read. I didn't know how much screen I was going to have, but I'll walk through what's up there. So there are, contained in the regulations associated with Article 10, a host of required studies, and the scope of those studies is in some general detail laid out in the regulations, but there have been particular studies that have come up in the wind especially, and now to a lesser extent solar context, that I think are worth pointing out, and pointing out some of the challenges associated with those studies. The first and the biggest is probably noise. I know everybody who works in Vermont in energy is familiar with the noise issues surrounding wind. I know there's been a lot of work going on in Vermont on that point. In New York, I don't have the number in front of me, but staff has essentially recommended that the siting board follow the World Health Organization and the NARUC standards when it comes to wind. The siting board hasn't weighed in on that yet, so that's just the staff position at this point. But you know, from a wind perspective, it's a bit of a difficult animal because you've got turbines in various locations. You need to figure out what the closest receptor is to any individual turbine. It's a lot of back and forth between acoustics experts combined with our Department of Health, who has an interest in the health and safety side of the noise aspect. The next study is visual. That one kind of speaks for itself. We go out and we have the companies identify sensitive visual receptors and then look to see if the project can be seen from any of those locations. EMF studies, again, New York State has a policy statement in place on EMFs. I think it's 200 milligauss at the edge of the right-of-way for a 115 kV transmission system. We have developers look at that as well. Land use, and this is where solar kind of comes into play. We're starting to see utility-scale solar projects proposed in the 90 plus megawatt range, which, you know, you're talking about 1,000 plus acres of land. Most of the time, what these developers are coming in with are to use agricultural land, most of the time marginal, sometimes less marginal cropland, sometimes not used at all, other times in service. So that's going to be a balance that has to be struck. Studies on rare, threatened, and endangered species, again, pretty straightforward in the wind context, though we're just now learning that in the solar context, there may be some disruption of habitat for field birds and the like. Decommissioning, what's the company plan to do when the asset's lived its life? Staff has again recommended that some bonds be put in place up front in the wind context to ensure that decommissioning is funded. Jobs and economic impact modeling. This is a bit of an outlier in that we don't actually care what the developers come in with. There's no model that the New York State Department of Public Service hangs its hat on in this context. We are actually more interested to see if anybody can come in to us with real world data, what previous projects in other states may have contributed. And then just one last point on this, which is military installations. There's recently been a lot of controversy surrounding about 5 or 6 wind projects in the vicinity of Fort Drum, less from the military itself than from the communities that are worried about impacts to the base from an economic standpoint. So it gets into the next slide I have very nicely, which is how to approach regulators and stakeholders. So early involvement is the key. Our PIP process forces early involvement with regulators and localities, but getting there on the ground long before you intend to file an application or come to them with a proposal is important. Getting them comfortable with the technology. A lot of the time, even in an agency like ours, there is still a learning curve when it comes to solar or wind, how the projects work, how they're laid out, how they're designed. The fact that, for example, with solar, you design to a number and then you put the panels in the field and you size the inverters correctly. Under the old fossil fuel system, developers would try to play a lot of games with that and try to put out more energy than they were necessarily certified for. So it's learning curve, things like that, right? Often involvement, again, come back, talk to the regulators over and over again. I get annoyed with them sometimes, but I know it's a good practice for them to follow to keep us engaged on where they are with the municipalities, what studies they've completed, if they're having any troubles. Hand-holding engineers and attorneys, like I said, especially attorneys, some of whom, at least in our agency, have been with the state for 30 years but have never seen a solar project. Get them out in the field, get them out to see these things, get them, again, comfortable with the technology. Impacts on local laws and town boards. This one's a little bit different. So in New York, we've got a centralized siting process. That's what Article 10's about. And the siting board is empowered to essentially overrule, set aside local laws that are deemed unduly burdensome. What does unduly burdensome mean? We're not quite sure yet because we're still fresh into the new law. But what I will say is that the siting board, at least in New York, I think will probably want to respect home rule. We're a home rule state, and to the extent that municipalities have a clear wish when it comes to allowing solar, allowing wind, allowing them in certain places, those factors are obviously going to be considered. So, if you've got a project that looks great for an area, but the town law doesn't let you build it, you got to really go to the town. You can't rely, at least in New York, on the siting board to overrule that for you. So I'm almost out of time, so I'm just going to go through some lessons and takeaways here. So while states, especially New York, want renewables, we've got a 50% RPS standard in place. There are factors that need to be balanced, and renewables are good. They're great, but there are downsides to each one of the technologies, and that needs to be recognized when you come to regulators and when you come to municipalities with projects. The overly rosy forecast with solar or wind is going to be the panacea for everything. Either we don't believe it or we immediately distrust it, whether that's good or bad. It's the truth, and it's helpful to come in and be clear about what some of those detriments are. Like I said, proposing new technologies is often very uncomfortable. New business models are equally as uncomfortable. Carl touched on REV a little bit, and that's nothing but new business models. So we have an entire agency at this point trying to feel our way through new business models on both the rate side and on the generation side, and it's a struggle. We're making progress, but it's definitely a struggle. And then I just want to come back again to constant and early engagement. Talk to the regulators, talk to the municipalities. That's really the key in managing the relationship if you want to build a project and ultimately if you want to get renewables deployed. So with that, I think I'm just about out of time, and thank you very much, and I look forward to any questions.
So a lot of really interesting ideas there. We're going to open it up to questions from the audience. We have about 15 minutes. And so if you have a question, if you would just come up to the microphones at the front of the room.
I want to just ask a question to something that Stephen touched on, that's offshore wind. And given that Massachusetts and New York both have a great offshore wind resource off their coast, and both are, the state policies are showing some early and great leadership for this technology. I just wonder if you could talk a little bit about what you think role this resource can play, and what can the states continue to do, including other states here in New England, to help foster this important renewable resource.
I'll jump in first. So in New York, New York's pretty actively engaged in the federal process of identifying appropriate areas for offshore wind deployment. It's early stages, but New York, through NYSERDA, the New York State Energy Research and Development Authority, is actively developing sites, developing maps, going out and doing analysis. I think there's a big filing deadline coming up with the feds soon, so I don't want to get ahead of what they intend to propose, but New York wants offshore wind. The real challenge is actually going to be in the transmission siting side, trying to figure out routes to get offshore wind into what's essentially going to be either Long Island or New York City in a cost-effective manner. That's going to be the challenge for us.
Yeah, I'll just add also briefly, the concept of offshore wind has become sort of accepted. It went into the governor's lexicon as one of the solutions for the closing down of Indian Point. It's gotten political traction. That has been years of work by a group of dedicated advocates, Kit Kennedy at NRDC, among many others who have just been putting the information out there, getting people familiar with it. From a technical point of view, the important thing to remember about offshore wind is it's damned expensive. So you need the right load for it, and you need the right story for it. And the right load and right story that we have in New York is a term that people can explain to you later on, a load pocket. It's called New York City. So it's really hard to get electricity into it. If you have a load pocket, you make a good case for an expensive resource over the cheap resource. And it also helps if you can point out that it's more valuable than the cheap stuff.
Yeah, boy, offshore wind. I could talk for hours about this one. Number one is I'm very excited and convinced that New York will be moving very rapidly, given that the CEO of NYSERDA used to be my boss at Mass CEC. And she is darn determined to make sure that New York outpaces Massachusetts. So let the games begin. So I'm very, very encouraged by not just the work that's gone into it in New York up to this point, but certainly the leadership team that's there is going to continue pushing it forward. I think just real quickly on the cost issue, which is really going to be the driver and has certainly been the focus of the conversation in Massachusetts. Just a couple of data points, and this also goes a little bit to the load point, is the project that was built. There actually is a project in the United States, as some of you may be aware, off of Block Island, south of Rhode Island, built by Deepwater Wind, commissioned roughly a year ago. That is ballpark 25 cents or so a kilowatt hour, which is expensive, but not as expensive as the 1 million gallons of diesel fuel that Block Island was transporting to the island and using on the island on an annual basis. So they cut their costs roughly in half. Now, there's very few places, that have 50 cent a kilowatt hour prices. Even Massachusetts, which is relatively high, is not that high. So that is a point, is that the cost is very important. There are certain situations where it's a no-brainer, but those are few and far between. So what does that mean? That means that you need to drive down the cost curve, right? And you're certainly seeing that happen in Europe. The bids that are coming in now in Europe compared to those 2 years ago, they've dropped by 50% in a mere 48 months. Now those cost curves aren't going to drop in the United States quite that fast, because they've been doing it in Europe since the early 90s. But frankly, some of the bid prices that I've heard from Massachusetts. So I mentioned the offshore wind process that we have going on. We actually have another roughly termed clean energy process going on, which was originally intended to be hydro land-based wind, solar, that kind of thing. One of the companies, offshore wind companies, actually bid into that process. And from what I understand, those bid prices they feel will be very competitive with those other technologies. So I think that gives us some comfort and confidence that those cost curves will come down in the United States and will make these projects far more competitive than we think, than we have thought in the past. Just one last point. Massachusetts didn't just start on the journey to offshore wind recently. We've been dealing with a project proposal there since 2001. The, at least thus far, ill-fated Cape Wind project, which, regardless of what you hear, read, or what have you, was really a very, very important canary in the coal mine for Massachusetts. It's where we learned pretty quickly that you need to, and this goes to one of Graham's points on any sort of project development process, you need to start engagement real early. And that's one reason, that we've had over 100 stakeholder meetings for these new offshore wind areas. So, yeah, offshore wind, I think, is a tremendous opportunity, and I'm real optimistic that you'll see it not just Massachusetts, New York, but up and down the East Coast.
Just wondering if you guys had any experience or barriers or areas for improvement within intellectual property as it relates to clean energy, as it's an important national and international policy that protects these technologies as well, which reduces the risk and finance for investment. Thank you.
So our experience, or my experience, I'm not an intellectual property attorney, but certainly on our technology development, that side of our shop, as well as the company investment, it's a key issue. And I don't think that that's particularly unique to this industry. When we're working with early stage startup companies that are coming up with the latest and greatest and newest ideas, it's a key question that any investor asks is, what are the barriers to other companies entering the market or the technology space that you're looking to get into? So it's an issue that is as significant for this industry as it is for any other technology development and technology-based industry.
Yeah, I'll just add a couple of quick points. First of all, there's a lot of interesting issues coming up in IP regarding trademarks, and I've got a lot of experience with that because we created the Green E many years ago as a certification mark for green power, and that's not sort of patenting, but we hired the lawyer who did trademark protection for Hell's Angels for that winged wheel, and our answer is we're going to sue you. That's pretty much the strategy there. On the other side, unfortunately, the level of research and development in the electric utility industry has all but disappeared. So our national labs are probably the only real place where original patents are, and universities, and they often work with the labs, are being created. They're pretty tied up. They're good about locking in the patents. Every now and then something will escape overseas. We had a big issue with superconducting technology being used in wind turbines, stolen by a Chinese wind turbine manufacturer, and made a lot of trouble for American Superconductor for a long time. But those are really high-level sort of disputes. We tend not to have a lot of basic patentable technical work going on in this space right now outside of the labs and the universities.
We have time for one more question.
This question is specific to the value of solar, and I thought it was a really interesting concept in disaggregating what a kilowatt hour is. But in some ways, it's certainly very complicated for people who maybe don't have a grasp of economics or sort of what that looks like. And so what are strategies for getting that integrated into rate making across all these different utility commissions and dealing with commissioners who maybe don't have that economics background or understanding? And what are the successes you might have seen so far, and what are the challenges there?
So You got to be, I actually had to do a little kind of pecha-kucha on this the other day. Let me boil it down real fast because sort of the time limits. First of all, you can't assume you need a problem. Net metering was a problem. Utilities were worried. You have to identify a problem. Then you have to identify a solution. You have to explain it in simple enough terms that people can get it. I actually used a little let's make toast thing about why solar avoids a lot of costs that making toast with coal imposes, and use that a lot. You have to be shameless in your promotion. I learned to do Twitter stuff and stuff because I wanted to promote the value of solar concept. You have to have a network. Friends ask me in to help explain the ideas. You have to be able to speak from different perspectives. When I was talking to utilities, I explained what a utility guy is thinking when he encounters this and why this might be a way out of his problems. You have to be watchful for your friends. I was attacked for 2 solid years by the Alliance for Solar Choice, who wanted to kill the value of solar concept, even hiring Skadden Arps to file a request for a private letter ruling at the IRS. And you have to just stay the course and beat that back, and then you have to put aside a little money to have a party to celebrate when you finally beat them down, and it becomes, a kind of a very popular idea that people understand. At the very start, I'll also say, rare for the utility industry was to use a phrase that everybody felt they could kind of understand. My staff actually proposed 3 or 4 different tariff names, all of which were geeky utility terms. And I'm proud that I said, no, we're gonna call it the value of solar, because that's what we're gonna compensate solar customers, the value of their solar. And that helped it become a little bit of a meme.
I think I'll just add, and Carl touched on it, but finding the right way to engage, I think, is also important. Finding the right proceeding, the right commissioner to start with. That's often overlooked by, not the bigger organizations, but a lot of the smaller organizations. They come at everybody at the same time when a more targeted approach is often more successful in the long run.
Great. Unfortunately, that's time. I know I myself have a lot more questions that I'd like to put to you. If we could just give a round of applause for our panelists and we'll move on.
Thank you, panelists. We now have a much firmer grasp on what we need to do in the renewable generation area to see a cleaner energy system. We will reconvene at 11:20 for the next panel on the non-renewable generation and what that means for our energy future. Thank you.
Interested and engaged in different positions, and you can have